Mergers and acquisitions. Mergers and acquisitions, or M&A in general, refer to those transactions which involve the integration of two or more organizations or consolidation of their assets or business verticals. The organizations involved in such deals could be either within a country or across countries, resulting in a cross-border transaction. While the terms merger and acquisition are often used interchangeably, technically there are some differences. In merger, two or more organizations come together to form a new organization. For example, Citicorp and Travelers merged to form Citigroup Inc. In acquisition, one organization buys or purchases the other organization. Google's acquisition of Android is an example of an acquisition deal. So why do organizations get into M&A deals? The key purpose is value for the participating organization. Money is an important value proposition, but in addition, the other important factors are growth opportunities, increased market share, capability development, access to intellectual property rights and technology, diversification of risk, economies of scale, access to larger client base, to name a few, that would otherwise not be possible through organic growth. So what are the different types of M&A deals? Broadly, M&A deals can be classified into four categories: vertical, horizontal, concentric, and conglomerate. In a vertical deal, organizations providing different products or services but for the same end product come together. For instance, a company manufacturing automobiles joining together with a company that supplies various components that go into manufacturing automobiles. In a horizontal deal, organizations which are in the same industry providing the same or similar products or services to the same customers come together. Facebook and Instagram deal is a very good example of a horizontal deal. In a concentric deal, organizations in the same industry, serving the same customers, but providing different products or services come together. For instance, companies in the insurance industry providing different insurance products, joining forces would result in a concentric transaction. Conglomerate deals, though not very common, involve organizations in different industries. We can take the example of eBay and PayPal. As with any business transaction, M&A deals also come with risks. So what are these risks? Wrong valuation of assets and liabilities resulting in overpayment or undervaluing, cultural differences, incomplete due diligence, underestimating the time and resources required in bringing the organizations together, poor implementation of the entire integration process, and legal risks, especially in cross-border transactions. So to mitigate these risks, certain measures to be adopted by the concerned parties are: topping the list would be due diligence. The parties must undertake necessary due diligence, both the financial as well as on the legal side. If it is a cross-border deal, engaging local firms, law firms, and investigating agencies are key. It is important to consider both ongoing and threatened litigations against the target company and the potential impact of the outcome of those litigations. Tax consideration is another important exercise. Capital gains, double taxation, tax incentives are all key factors. The third important measure is to engage an independent third party to do the valuation. This would mitigate the risk of overpayment or the transaction being undervalued. Regulatory compliances would be the other important measure. Obtaining the approval of the board and shareholders and ensuring that all statutory filings are completed in a timely manner. Consent from creditors would be another measure. No objection certificates or no dues certificates must be obtained from creditors prior to the transaction. Public notice might be required for certain transactions. The parties must obtain proper records and maintain those records. This will bring transparency in the deal and also form key evidence in the event the transaction comes under scrutiny by regulatory authorities. Contractual protections with particular focus on representations, warranties and indemnities could give additional protections. While these risk factors and measures could help mitigate some of the pitfalls in an M&A deal. To summarize, mergers and acquisitions in the corporate world have created success stories and have also seen a lot of failed attempts. There is no one size that fits all in such deals. It is therefore highly recommended to proceed with extreme caution, use expert advice, meticulously plan till the minute detail, and frequently assess implementation to ensure that things are going as per schedule. Thank you.